Hey guys, welcome back to the channel. Today we're stepping inside the bustling 248th Criminal District Court in downtown Houston, Texas, right in the heart of Harris County. And we're parking ourselves front row for 3 separate probable cause showdowns, all presided over by the no-nonsense judge David Fleischer. If you've ever wondered what really happens in those critical first hours after someone gets arrested without a warrant, buckle up, because this is where the rubber meets the constitutional road. Now, for the new viewers, let me break it down like we're sitting at the courthouse cafe. In Texas, the moment the cuffs click on and there's no arrest warrant already signed by a judge, the clock starts ticking fast. Article 15.17 of the Texas Code of Criminal Procedure, often called the 48-hour rule, ever since the U.S. Supreme Court hammered it home in cases like County of Riverside versus McLaughlin back in 1991, says the arrestee has to see a neutral magistrate without unnecessary delay, and almost never more than 48 hours later. This isn't just paperwork. This is the frontline defense against wrongful detention baked right into both the Fourth Amendment and Texas law. The judge has one massive job in that hearing. Look the arresting officer in the eye, listen to the affidavit or live testimony, and decide, right there on the spot, whether the facts add up to probable cause. We're talking the same standard that traces all the way back to the 1983 Illinois v. Gates decision. Is there a fair probability, based on reliable information, that this person committed the crime? If the answer is no, the defendant walks out of that courtroom a free citizen that same day. No bail, no charges, nothing. If the answer is yes, the case gets bound over, bond gets set, and the freight train of the criminal justice system starts rolling. And that's exactly what we're watching today. 3 completely different human stories, 3 officers on the hot seat, and 1 judge who isn't afraid to drop the gavel hard if the evidence isn't there. We're going to kick things off with a case that went down on the morning of November 4th, 2024. Just 6 days earlier, in the pre-dawn darkness of October 28th, 2024, a Houston PD patrol unit pulled over a silver Chevy Malibu weaving across 3 lanes on the Southwest Freeway. Behind the wheel was 29-year-old Raquel Rodriguez. What happened in Judge Fletcher's courtroom would spark a 15-minute legal chess match that had everyone, the deputies, the bailiffs, even the court reporter, leaning forward in their seats. Was this a textbook DWI with a rock-solid probable cause, or was law enforcement about to get called out for jumping the gun? Stick with me, because the officer's very first sentence under oath is going to set the tone for everything that follows. And trust me, Judge Fletcher was already raising that famous eyebrow before the guy even finished his introduction.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you now.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65 mile per hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, 1 leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1-leg stand. He also noticed that I think she took off her boots for the 1-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, I just an odor. Not even a strong odor at that, and then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? There's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, which is per,
But I
procedure for
get the
SFSTs,
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right. Please take a seat.
You could feel the air change in Judge Fletcher's courtroom the second he started reading the probable cause affidavit in the Raquel Rodriguez case. I've watched hundreds of these hearings, but this one was a masterclass in why the Fourth Amendment still has teeth. Here's what it boiled down to. Houston PD pulled Raquel over for weaving, no question about that part. The officer walks up, smells alcohol, and Raquel, trying to be cooperative, admits she had exactly 2 drinks earlier that night. The last one finished a full 2 hours before she got behind the wheel. That's it. That's the entire universe of evidence before the officer says, "Step out of the car, ma'am. We're doing field sobriety tests." Judge Fletcher leans forward, voice calm but sharp enough to cut glass, and asks the million-dollar question. "Officer, at what point did you develop reasonable suspicion of intoxication, not just drinking, intoxication, sufficient to turn a routine traffic stop into a DWI investigation?" The officer starts talking about the odor and the admission, but you can see Fletcher's already shaking his head. Because here's the thing the United States Supreme Court made crystal clear in Rodriguez versus United States back in 2015. Once the original mission of the traffic stop is complete, or reasonably should have been, any extension, even by a few minutes to conduct fishing expedition tests, requires independent, reasonable suspicion. Smell of alcohol plus, "Yeah, I had a couple drinks hours ago," that's not it. That's literally every person who had dinner at half the restaurants in Houston on a Friday night. Fletcher goes full professor mode. He cites the Texas Court of Criminal Appeals in State versus Cortez, reminding everyone in that room that the odor of alcohol alone is not enough. An admission of moderate drinking without more doesn't get you over the hump either. Then he drops the hammer. Because the officer lacked reasonable suspicion to prolong the stop, the entire field sobriety performance, the portable breath test, the walk and turn, the one-legged stand, all of it gets suppressed under Texas's exclusionary rule, Article 38.23. Poof, gone. With all the intoxication evidence wiped out, what's left to justify handcuffs and a trip to the drunk tank? Nothing, zero, nada. Judge Fletcher looks straight at the prosecutor and says, "The court finds no probable cause for the arrest. Ms. Rodriguez is ordered released immediately, and the case is reset for formal dismissal." And just like that, 3 months later, on February 24th, 2025, the Harris County DA's office quietly dismissed the charge for good. One more reminder that even in Texas, the Constitution still beats a hunch every single time. But we're not done yet. Same day, November 4th, same courtroom, totally different vibe. Next up is Keon Shaw, 24 years old, facing a charge of fleeing or attempting to elude a police officer under Texas Transportation Code 545.421. Now, on paper, this sounds dramatic, right? Lights, sirens, high-speed chase. Wrong. What actually happened on October 28th is one of those cases that shows how a routine traffic stop can explode into something way bigger in the blink of an eye. And whether Keon's decision to keep driving for 6 more blocks after the officer hit the overheads was criminal or just the worst panic-driven choice of his life. When Judge Fletcher calls the case, you can tell he's already read the offense report twice because his first question to the arresting officer isn't, "What happened?" It's, "Tell me exactly what signal you gave Mr. Shaw, how far away you were when you activated it, and why you believe he willfully ignored it." Buckle up, because the next 5 minutes are going to decide whether Keon walks out free or heads upstairs to face a Class A misdemeanor that carries up to a year in the county jail. This one's about to get real interesting real fast.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have him, because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man, good luck.
Here's what happened next on that same November 4th morning. And folks, if the Raquel Rodriguez case was a polite constitutional spanking, the Keon Shaw hearing was a full-on Fourth Amendment clinic that left the prosecutor staring at the floor. The officer takes the stand and starts reading from his report. I observed the vehicle traveling at a high rate of speed, so I initiated a traffic stop for speeding. That's literally it. No numbers. No, I paced him at 52 and a 35. No, my radar showed 68. Just the legal equivalent of, he was going fast. Trust me, bro. Judge Fletcher doesn't even let him finish the sentence. He puts his pen down, looks over the top of his glasses, and says, "Officer, how fast was Mr. Shaw going?" The guy hems and haws, says something about, "It looked really fast for the area." Fletcher fires back, "Miles per hour. Give me a number." Silence. Crickets. You could hear the air conditioning click on. That's when Fletcher drops the knowledge bomb everybody in that courtroom knew was coming. He brings up the 2005 Texas Court of Criminal Appeals masterpiece, Ford versus State, where an officer tried the exact same "he was following too close" vagueness and got shredded. The High Court said, and I'm paraphrasing here, "If you can't articulate the specific facts that made you believe a crime was happening, then you never had reasonable suspicion in the first place. No measurement, no estimate, no testimony about posted speed limits, nothing. Just a naked conclusion." Now here's the part that surprises a lot of people. Texas Transportation Code 545.421 says you can be charged with fleeing even if the original stop was bad, right? Wrong, at least not in the real world. Because when the stop itself is unconstitutional, every single thing that flows from it, including the accusation that Keon willfully failed to stop, gets poisoned through under Article 38.23, Texas's supercharged exclusionary rule. Think of it like this: if the tree is illegal, none of the apples get to come to the party. Fletcher lays it out like he's teaching a law school class. Without admissible evidence that a lawful stop was ever signaled, the state has no case. Boom. The court finds no probable cause existed for this arrest. Mr. Shaw is ordered released immediately. The prosecutor didn't even bother asking for a reset. The charge was dismissed before Keon made it back to the holdover tank. Two people, same morning, both walking out free because two different officers forgot that in America, "because I said so" has never been reasonable suspicion. And now, fast forward a couple months to January 27th, 2025, and we're about to watch something completely different. This one isn't about a traffic stop gone sideways. This is big boy felony territory. Francisco Serda, 31 years old, is sitting in the box wearing the orange jumpsuit because Harris County detectives are accusing him of engaging in organized criminal activity, a first-degree felony under Texas Penal Code 71.02 that can put you in prison for life if the underlying crime is serious enough. Translation: the state says Francisco wasn't just a regular thief, he was part of a crew, a combination of 3 or more people working together like in criminal LLC. In this case, the alleged racket was a string of catalytic converter thefts across Southeast Houston. Quick hits, thousands of dollars a night, chopped, shopped, and sold before sunrise. And when the task force finally kicked indoors on January 22nd, Francisco's name was at the top of their org chart. But here's the thing about Texas's organized crime statute. It's a beast. It turns a state jail felony theft into a first-degree monster the minute the DA can prove you were rolling with a squad. And to do that at the probable cause stage, they've got to bring receipts, text messages, surveillance photos, co-defendant statements, something that shows Francisco wasn't just a lone wolf who happened to know a couple other crooks. As the prosecutor starts laying out the evidence, you can see Judge Fletcher flipping through the arrest affidavit like he's speed reading a thriller, looking for that one smoking gun paragraph. And the question hanging in the air is simple but brutal. Did the detectives actually connect the dots, or did they just throw the biggest charge they could find on the menu and hope it sticks? Because if they can't, Francisco Serda is about to become the third person in 6 months to walk out of this exact courtroom with a smile and a story that's going to go viral on TikTok by dinner time. The prosecutor calls his first witness, a detective who's been on the task force for 2 years, and the very first question out of Judge Fletcher's mouth tells you everything you need to know about where this hearing is headed.
The last one, Your Honor, is Mr. Francisco Serda. He's a custody judge, and I wonder if I'm wrong on his.
Is that C or an S?
The C judge, okay. Oh, it's right here.
Good morning, Mr. Serda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Serda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
Judge, that's my concern. If you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged act.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Serda remained in the U-Haul. There's no further information regarding Serda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your
what
Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough. to
Dude,
bring charges.
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR and we don't have that at this time. So-
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. And we have to decide.
He's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ice hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Serda, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serda, be careful who you hang out with, Okay, all right, for sure.
And there it is. the third and final swing of the bat on January 27th, 2025. And Judge Fletcher just knocked another felony charge clean out of the park. The prosecutor stands up, chest puffed out, ready to lay out this big, organized crime conspiracy. Catalytic converter ring, 5 guys, stolen U-Haul, tools, saws, the whole 9. He gets exactly 1 sentence in. Your Honor, the defendant was located inside the stolen vehicle along with, and Fletcher cuts him off like a ref calling traveling. Counsel, slow down. Tell me what Mr. Serda personally did. Not the other 4 guys, not the group, him. What specific acts tie Francisco Serda to an agreement to keep committing these thefts over time? You could have heard a pin drop. The detective on the stand starts flipping through his folder looking for something, anything, that isn't just he was sitting in the truck when we rolled up. And that's the problem. That's the entire case right there. Presence, nothing more. Judge Fletcher doesn't even wait for the awkward silence to get painful. He goes straight into lecture mode, and when he does, every defense attorney in the gallery starts scribbling notes that gets the bar exam. He cites the Amarillo Court of Appeals 2000 decision in Munos versus State, still the gold standard a quarter century later. The ruling is brutal in its clarity. Being in the wrong place with the wrong people during one single criminal episode is not, has never been, and will never be enough to prove you signed up for a criminal enterprise. You need evidence of an agreement, evidence of continuity, evidence that this wasn't just the one-night crew that happened to invite Francisco along for the ride. And in this affidavit, crickets. No prior buys, no recorded calls, no Joe House snitch saying Francisco was the mastermind, no text messages about the next job, just a guy riding shotgun in a hot U-Haul when the lights came on. That might get you regular theft, sure, maybe even possession of stolen property. But engaging in organized criminal activity, first-degree felony, 5 to 99, not even close. Judge Fletcher looks at the prosecutor the way a disappointed dad looks at a kid who just brought home a report card full of Fs, and says, the court finds the arrest affidavit contains no facts from which a neutral magistrate could conclude that Mr. Serda entered into a combination or agreed to ongoing criminal activity. Probable cause is absent. The defendant is ordered released forthwith. Boom. Less than 9 minutes from start to finish. Francisco Serda walks out of the holdover before lunch, and exactly 1 month later, on February 24th, 2025, the DA's office dismisses the organized crime charge for good. 3 hearings, 3 warrantless arrests, 3 times the state rolled in thinking judicial review was just a formality, and 3 times Judge David Fleischer reminded everybody in that building why the probable cause hearing exists in the first place. Because here's the truth nobody in a badge or a prosecutor's suit wants to hear, but every single one of us needs to remember. The moment those cuffs go on without a warrant already signed by a judge, you have lost your liberty based entirely on one person's word. That officer's story is all that stands between you and freedom for days, weeks, sometimes months, while the system grinds along. The Article 15.17 hearing isn't a speed bump. It's the emergency brake. It's the first and often the only real chance a neutral judge gets to look the government in the eye and ask, do you actually have the goods, or did you just ruin someone's life on a hunch? When judges like Fletcher do the job the way it's supposed to be done, meticulously, fearlessly, line by line, they don't just free the innocent, they protect every single one of us. They prove the system can still police itself. And every time a person walks out of that courtroom because the evidence wasn't there, public trust in justice goes up, not down. So that's it for today. 3 more reminders that the Constitution isn't just words on old paper. It's alive and well in a little courtroom on the 10th floor in Houston, Texas, every time a judge is willing to do the hard thing and say no. Drop a comment below and tell me which of these 3 shocked you the most, or better yet, tell me what courtroom or what case you want me to hunt down next. Hit that subscribe button, ring the bell, share this with someone who needs to see that the system can still work. I'm out here digging up these stories so we all stay informed, stay free, and stay loud. See you in the next one.